Greetings, everybody. Alvin and Gunther and Missy, thank you for your help, all your work in developing, preparing, and implementing this program. And thank you, all of the panelists, for educating me throughout this conference. And this point can't be stressed too often, although it's been stressed often, for your wonderful and significant efforts to help protect the Jewish people. Because the title of the conference refers to anti-Semitism in America, my focus is on United States law. The plight of American Jews has become increasingly perilous. There are disparate types of speech that not only exacerbate Jew hatred, fundamentally injure the human dignity of Jews, intimidate them from embracing their Jewish identity, and ironically limit their de facto freedom of speech, but are linked to violent anti-Semitic outbursts against persons and property. Of course, there's the threat of even more catastrophic results as hatred of Jews continues to be promoted by politicians on both the left and the right, and as demographics continue to change, bringing in voters and voices from disproportionately anti-Semitic populations, and as the memories of the Holocaust are ignored, diluted, distorted, denied, or forgotten, the specter of much graver consequences looms. Allow me to start with the following anecdote. I was once asked the following question: what is it that has whiskers, runs away from dogs, runs after mice, purrs, and is made of cement? So I said, I don't know. Whereupon I was told, a cat, of course. But I said, a cat isn't made of cement. Oh, I only threw in the cement to make it hard. Well, my task addressing possible weaknesses in America's First Amendment law is inherently hard. As Frederick Schauer has written, much of the academic discourse for an absolutist approach to the First Amendment meets many of the hallmarks of an ideology, a viewpoint held tenaciously in the face of very significant contradictory evidence. Similarly, Stanley Fish contends that, quote, elements of pure assertion and blind faith, unquote, characterize the arguments of those who claim that only complete adherence to totally free speech guarantees a secure democratic future. Others, in talking about hate speech, talk about the sort of self-righteous or hubris of some people. Charles Lawrence, professor at Stanford, says, I cannot help but believe that those people who speak of offense, those who argue that this speech must go unchecked, do not understand the great difference between offense and injury. Similarly, Charles Downing of the University of Texas says, when by dint of legal focus, individual cases are at center stage, the debate often descends to having First Amendment absolutists ask the thick skin question. Everybody gets insulted at some point in their lives, so they should, someone on the receiving end of a racist or homophobic or other insult shouldn't be so delicate and sensitive about it. Grow up and get over it, is the implied advice. But as Matsuda et al. Say, citing a study, legal insiders cannot imagine a life disabled in a significant way by hate propaganda. Although many commentators have suggested alternative justifications for an absolutist version of the First Amendment, the United States Supreme Court has generally not embraced those theories. Instead, the rationale repeatedly cited by SCOTUS is its reliance on an argument first mentioned by Justice Brandeis in a dissenting opinion in 1927 that the best and only cure against the harm of negative speech is more speech, a rationale that is more commonly known as reliance on the, quote, marketplace of ideas, unquote. However, reasonable, limited regulation of some of these categories of speech may significantly ameliorate not only the serious harms inflicted on Jews, but also similar injuries visited on other commonly situated groups such as blacks. However, American First Amendment doctrine, as it currently stands, appears to foreclose such regulation, although I suggested in my paper that it can be interpreted a bit differently to allow some flexibility. My paper that I'm working on will argue, one, that the US First Amendment doctrine is predicated upon a largely false rationale, two, that modern development psychology changes in the ways in which information is shared and consumed highlight and underscore the shortcomings of this rationale, and that there may yet be room for the Supreme Court to make marginal revisions regarding some First Amendment issues. As some of you may know, law review articles are typically quite extensive. So today I'm going to try to mention without fully developing some of the issues that are central to the paper. First, however, I've got to make a few preliminary remarks, and the preliminary remarks may take a lot of time, but I think they're important. Number one, America's First Amendment doctrine can interfere with efforts by other countries to curb disfavored speech in their own lands. Foreign racists and Jew haters can funnel information to Europe and elsewhere through cognate hate groups in the United States. So any leniencies as to the publication of such information in the United States laws can cripple efforts to control this kind of speech elsewhere. Although foreign countries might enact extraterritorial laws designed to cover actions in the United States that have an impact in their own countries, such as the dissemination of hate speech over the internet, any judgments that would be entered in those countries would probably not be enforceable in the United States. The United States courts would likely find that enforcement of the judgments would violate America's public policy of free speech, and therefore the enforcement of those judgments would be against public policy. Two, constitutional law in the United States can change. Brandeis' statement about more speech being the cure for bad speech was, by the way, voiced in a dissent. Indeed, SCOTUS First Amendment doctrine has changed dramatically in the past 50 years. Constitutional law can change, for example, because the court recognizes new psychological insights or new facts on the ground. In Plessy versus Ferguson, the Supreme Court held that equal facilities, if indeed equal, could be provided on a racially segregated basis. But many scholars interpret Brown versus Board of Education, which reversed Plessy, as having been predicated on the court's appreciation of psychological injury that arises from racial segregation. Nor must the change be unidirectional. Some of you, but probably not many, are old enough to remember the time that the constitutionality of laws limiting the free exercise of religion was, at least in word, based on the same test as laws limiting free speech, as would probably be the natural import of the both types of rights being protected in the First Amendment. Yet speaking for a sharply divided Supreme Court, Justice Scalia changed all that in the Smith case, upholding application of Oregon unemployment laws that limited the religious rights of Native Americans, and that case severely reduced protection of religious rights. Four, there are many types of injurious speech. Their harms vary in type, severity, and likelihood. It's possible to consider specific modifications of some types without addressing others. The blanket unwillingness to consider any changes is a symptom of the ideology to which Schauer referred. Of course, the rejection of all proposed changes, even if the result of due deliberation, is perfectly rational. But the idea is that it's very difficult, and that's why many of these preliminary comments, to get through to some audiences that have an open mind. Okay, some types of harmful speech have nothing to do with their truth or falsity, incitement to violence. So under Brandenburg, the Supreme Court held that incitement to do violence can only be regulated if it gives rise to an, quote, imminent, unquote, harm. The court did not link imminence to the likelihood of harm. Instead, even if the likelihood of the harm seems inevitable, Brandenburg appears to block regulation unless the harm will be nearly immediate. That doesn't strike me as reasonable, and certainly the court doesn't point to any compelling argument as to why that imminence should be the requirement if it's not related to the likelihood of the harm. Last Tuesday, Professor Al Azdi referred to some of the sermons in American mosques. I've also listened to many videos and reports regarding those speeches. I believe that some of them at least constitute an incitement to violence that ought to be subject to regulation, even if it doesn't mean that the people in the mosque are going to immediately do violence. Some of these sermons and much other Jew-hating speech, especially on college campuses, may constitute threats, intimidation, and bullying, which should also be subject to some regulation. And again, depending on how you read the Supreme Court cases, you'll see what type of flexibility there is. In 2019, Professor James Loeffler, by the way, in order to say, I'm going to be quoting some people about their studies or about their opinions without giving you citing all the studies and opinions to save time. But this is an opinion. He's a professor of Jewish history at the University of Virginia. He wrote in The Atlantic, Jews will not replace us. When 300 neo-Nazis marched with flaming torches to the central quad of the University of Virginia on a late Friday evening in August 2017, their message was clear. The college's response, in contrast, was a study in confusion. As a public institution, wrote then President Teresa Sullivan, the university, quote, must abide by state and federal law, unquote, regarding the First Amendment rights of free speech and freedom of assembly. Yet after the violent weekend that led to one death and multiple casualties, UVA lawyers unearthed a decades-old state law, still on the books, that banned the burning of objects on private or public property, quote, with the intent of intimidating any person or group of persons, unquote. It turned out that the Virginia General Assembly had dealt with this very problem back in the early 1950s when the Ku Klux Klan tried to launch a new campaign in the state. The legal means to prevent this racist and anti-Semitic menace without violating the First Amendment had existed. No one had remembered to look for it. Professor Alexander Tsitsis of Loyola University College of Law has advocated a federal anti-incitement law and the best parameters of such a law to be debated. There are types of harmful speech where truth or falsity is material. And I think that although this is obvious to probably most of you, still I've met many people who just don't get it. It's important to underscore the fact that American law and all legal systems that I've ever heard of presuppose that the factual truth is subject to possible judicial determination, even when the stakes are high. The most obvious example is in criminal law. Did the defendant commit a crime? And is the defendant going to be severely punished for that crime? That's a fact, and it can be determined. In the Nuremberg trials, evidence was introduced and findings of fact were made, not merely regarding the direct actions of individual defendants, but also as to the nature and extent of the Nazi atrocities associated with those acts. Similarly, English courts determined the truthfulness of Deborah Lipstadt's comments. It's important to understand that courts can, even though as academics we often question epistemology, whether something is true or isn't true, but as a matter of public policy and law, it is settled that courts can determine facts. However, the relatively recent SCOTUS opinion in a case, the Alvarez, regarding the stolen Valor statute, which was a statute that made it criminalized for people to assert that they received certain medals or they received certain government honors while they served in the military and so on. The Supreme Court changed America's First Amendment doctrine again and again, and I believe in a decision written by Justice Scalia with dissenting justices saying that this is not what the law is, not what the Supreme Court has said the law was in the First Amendment. He wrote that even intentionally false statements are entitled to First Amendment protection so long as they don't hurt anybody. This was a case where a public official attended an official meeting of the panel of which he was a member, and he just started lying about his heroics and his honors that he received and what he had done, clearly knowingly false. And other justices in the Supreme Court said this is, we've always said that intentionally false statements are not protected, and this was a change in the law. Obviously, legal system can actually determine facts regarding a person's state of mind. Did a person act with subjectively discriminatory purpose? Did someone commit fraud when he made a contractual promise? Did the person actually do so while silently intending not to fulfill it? In a business deal, did someone make a misrepresentation knowingly or only negligently? Was someone's transfer of assets done fraudulently, e.g. for the purpose of placing them beyond the reach of the creditors? Did someone commit perjury by knowingly giving false testimony? Was the person merely mistaken? So law students often ask, how can you prove what someone's intent was? And the answer is, despite the possibility of having a smoking gun, usually there's circumstantial evidence such as the kinds of factors mentioned in support of the IRA definition of anti-Semitism. Libel, group libel. Yesterday, Pamela Nadell mentioned Henry Ford and the Dearborn Independent. What ultimately stopped the spewing of Jew hatred from the Dearborn Independent was the libel suit filed against Henry Ford by Aaron Shapiro. Now, he could only file a personal libel suit because Michigan had not enacted a group libel law. However, Jewish activists, such as including the AJC, had been at the forefront of promoting enactment of criminal group libel laws. Over time, this position changed. And interestingly, at least one author has argued that as American Jews assimilated, their perception of themselves as a distinct group, or as Am Yisrael, as Naya mentioned yesterday, I believe, diminished and their support for group libel legislation abated. The last Supreme Court decision that specifically dealt with criminal group libel law, Beauharnais, upheld the statute as it applied to the libeling of blacks in Illinois. And while there's certainly debate as to whether this opinion retains its vitality, Professor Tsitsis cites a number of cases, subsequent Supreme Court cases that have continued to refer to this Beauharnais decision in a positive way, suggesting that it still has some vitality. But what about the weaknesses of SCOTUS's First Amendment rationale, the marketplace of ideas? Well, the marketplace of ideas came from the notion of the marketplace, the real marketplace, the economic marketplace. But even in the economic marketplace, we have restrictions. We have antitrust laws, we have child labor laws, we have safety regulations, we have collective bargaining laws, we have consumer protection laws. We don't have a free marketplace in the economic marketplace. We haven't for a long time. Justice Brandeis's more speech, it is the core statement, actually said the following: if there be time to expose through discussion the falsehood and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence. So I basically have three concerns about this. Number one, is it likely that discussion will in fact avert the evil by the reaching of right conclusions? Number two, even if faith in the ability of this discussion will ultimately enable a majority of the community to reach truth, what about many people, even if only a minority, whom the bad speech will convince? And number three, even if faith in the ability of such a majority of the community to reach truth is justified, what about the pernicious harms that the bad speech has wreaked in the meantime? Remember, if there is time, and speech, including bad speech, can be disseminated very quickly, the impact can be felt quickly. Back to question one, is it likely that discussion will avert the evil by the reaching of right conclusions? This rationale appears to depend on the assumption that people are rational and are generally able to discern between true and false speech. Well, I know we heard Naya Lech talk about the high school and college students she's taught about anti-Semitism, about how they're not really they're not prepared to properly and rationally evaluate the information. In fact, they have very little information. I've taught in law schools, and those are students who have successfully gone through a college career in order to be able to get admission to law schools. And I certainly am not sanguine about the ability of the average law school student to be able to rationally come to a conclusion about these issues. I'm not sure about your own anecdotal experiences, but I suggest that at least many of the people with whom I've spoken agree with me. By the way, has the marketplace of ideas eliminated the problem of Jew hatred yet? Has it eliminated racial hatred yet? I don't think so. At least I didn't get the memo. Duke Professor Philip Napoli says the following: this literature across fields such as communication, cognitive psychology, and behavioral economics illustrates how established behavioral patterns such as selective exposure, confirmation bias, heuristics for coping with information overload, and directionally motivated reasoning explain how false news can be favored over legitimate news. Confirmation bias. For example, we know that one's pre-existing conscious or unconscious biases may affect their beliefs and their interpretation of new information. We also know that people can formulate opinions on the basis of the first information they received, and that those opinions, once formed, can bias them against the proper construction of other information. One of the phenomena is referred to as anchoring. Anchoring is a heuristic that describes the subconscious use of irrelevant information. Professor Derek Bambauer, a fellow at the Berkman Center for Internet and Society at Harvard Law School, says as follows: where we start determines where we end up. In evaluating problems and deriving answers, people frequently begin with an estimate or baseline, then refine it. However, research demonstrates this initial value has a powerful anchoring effect. Our final analysis reflects strongly our initial value, and our adjustments often fail to reflect available data. Even completely arbitrary starting values affect our analysis. For example, researchers spun a wheel of fortune to generate a number between 0 and 100, then asked study participants who witnessed the spin, didn't do the spin, but witnessed it, to estimate the number of African countries in the United Nations. The spin results had a marked effect on subjects' estimates. Anchoring is not reduced even by providing rewards for accuracy in the final answer, and it can cause overconfidence in our assessments. Even sophisticated individuals aware of this bias are nonetheless susceptible to it. Then consider some of the ways in which information is distributed and received. So Professor Napoli says, the bottom line is that the notion of the rational audience capable of processing speech from diverse sources and capable of effectively and rationally assessing the truth, quality, and credibility is much more an ideal type in First Amendment theory than in empirical reality. What may be different today, however, is the extent to which the US media system is capable of counteracting these fundamental human tendencies. Instead, it may be exacerbating them. So for example, he lists many factors that indicate that this problem is being worsened. Number one, there's a decrease in legitimate gatekeepers for the truth. Number two, the number of legitimate sources of news has been diminished. There are fewer newspapers. There's a decreased size of TV newsrooms. There's fewer professional journalists. There's a phenomenon known as parasitic journalism. Parasitic journalism, where many information sources merely repeat stories originated by others. And often the credibility or even the identity of the originators is not made known. There are economic incentives for the increased production of false news. As he says, the relative production of legitimate news and information compared to false news and information is in the midst of perhaps an unprecedented decline. Reputational information that might have helped guide rational decision makers in the past has been impaired by the decrease in the number of professional journalism positions and in problems with the reputation of traditional news outlets. It's also increasingly easy with the internet and social media to target those who are especially vulnerable. The interactivity of the internet is a data-driven phenomenon. As Napoli writes, within the context of counter speech, that more speech that counters the bad speech, this means that those with an economic and or political interest in the dissemination of false news are now far better equipped than in the past to deliver their content to those they most desire to reach, targeting exclusively right or left-leaning news consumers or other more specific political traits with false news or information has never been easier, as observable social media activity provides a host of reliable indicators of an individual's political orientation. In these ways, the magnitude of the evil, to use Brandeis's term, that false speech can achieve is amplified. And it's also less likely that people will hear the counter speech. Why? So again, Napoli, given the empirical connection between partisanship and falsity, to the extent one's filter bubble has a partisan orientation, the likelihood of fake news making it through the filter bubble increases. At the same time, the likelihood of legitimate news that counteracts that fake news decreases. The current state of play is perhaps best termed the spiral of partisanship. In this scenario, the increased media fragmentation and personalization that began in the 1980s with the development of cable television, then accelerated through the 90s and 2000s with the rise of the internet and social media, simultaneously facilitates the mutually dependent phenomena of the rise of more partisan news outlets and the selective exposure to more partisan news. These are mutually dependent phenomena in that partisan news outlets require an audience to justify their existence, and more partisan news consumption requires the availability of more partisan news outlets. So I've only mentioned a few of the heuristic issues and a few of the issues with respect to the internet. there are many more. I listed 3 questions originally. I went through basically the one as to whether it's really reasonable to believe that people will reach through the marketplace of ideas rational decisions. The other 2 questions I want to just mention again as I close. The second was, even if faith in the ability of such a discussion ultimately to enable a majority of the community to reach truth is justified, what about the many people, even if only a minority, whom the bad speech will convince? And finally, even if faith in the ability of such a majority of the community to reach truth is justified, ultimately, what about the pernicious harms that the bad speech has wreaked in the meantime? So I sort of urge you to encourage your other academics to have a more open mind about considering possible massaging of First Amendment doctrine to try to ameliorate the problems that we face and that other minority groups face.